Thank you, Pearson. I always enjoy coming out and speaking to this group because one of the things that I love are entrepreneurs. And I guess maybe one of the reasons I like entrepreneurs is I like to think I are one myself. I have a small business, and I know, like you, what it is to come up tomorrow payroll or the end of the week for payroll and have to decide what gets paid so that your folks can get paid. So I'm right there in the trenches with you. And one of the things that I have enjoyed about my practice, I started out doing mainly employment law in a big firm, representing companies that had been sued for employment-related problems or had disputes between business owners, that sort of thing. And one thing I really enjoyed about that practice was you got to get into just a number of businesses and figure out how they work. And I didn't really realize it before that, but that's an area that I just find fascinating, how American business works and how creative people can be, both positively and negatively at times, in order to make money. And so this particular talk kind of comes out of my experience in business litigation, of seeing how things have gone wrong and how expensive it is to clean up a mess once it's been created. And so the point of this talk is to help you avoid business litigation, help you have a profitable business. And some people say, well, Alan, isn't that taking money out of your own pocket because you're telling people how to avoid disputes? And I said, well, one of my many philosophies is that the best thing that you can do to your worst enemy is to give them good advice, because they won't take it. And so, not that anyone here is my worst enemy. In fact, I see a lot of friends in the room. But, these are things that some of them are probably painfully obvious to many of you. Some of them hopefully will be things that you haven't ever thought about before. But it really does. We were talking before about what the talk was going to be, and I think the best advice, if you sum everything I'm about to say up and you say, I want to take one thing away from this talk, is to be strategic. And to be strategic in a way that doesn't just look at where you are today, but looks at where you want and expect to be in 5 or 10 years, and then act like that's where you're going to be. Plan for the future, plan for success, both legally and from a business standpoint. And so my goal here today is to go through these 5 points, give you some of my thoughts on each of them, and then what I really would like to do is talk about what you want to talk about, to answer your questions, and to have a dialogue that hopefully what you come away with today is vibrant and alive for you, and not just what I want to talk about. The first, there are 5 topics, and I'll just quickly tell you what they are. The first is we're going to cover a little bit of employment law, compliance, and some theories on how to approach that. The second is intellectual property protection and ways to look at that. The other is to talk about your agreements, and my main focus there is you need to have customized agreements. I do not believe that there is any such thing in the world as a standard contract. If someone tells you, oh, that is a standard contract, do not sign it, because that means that you are going to get screwed. All right? So that's my deal there. The next is risk management. We're going to talk about a lot of different kinds of risk management plans. The things that cannot happen to you are going to happen to you. And so you need to have a risk management plan. The next, and then the last is to talk about mentors and advisory boards. And basically I call that get off the island. I had a statistic brought to my attention not long ago that the suicide rates for dentists was the highest, if not among the highest, if not the highest in professionals. And my uncle's a dentist. Many of y'all may know Dr. Alan Crone, who practiced here for many years. And I asked him one day, it was at Christmas or something, and I brought that up, and I said, why do you think that is? And he thought back and he says, you know, it may be because so many of us practice by ourselves. We don't have someone to talk about on business. And when you're a professional in an office with just with support staff and people who work for you and no one really on the same level that you are, it's hard, isn't it, to really confide in someone who reports to you and to get advice from someone who reports to you. And so and I don't think it's just for dentists or lawyers or those kind of professionals who practice in professional settings where they may be the only lawyer or they may be the only dentist. I think it equally applies to entrepreneurs who are running their business and they really don't have anybody that they can talk to. And I think it's important to be able to bounce ideas off people. It's important to be able to cry on somebody's shoulder. Sometimes it's the stress and the worry is just so much that you really need to confide in somebody, and I think that's important. So let's continue to talk about the last shall be first. So let's talk about mentor and advisory boards. I know a number of my clients have created advisory boards, or actually board of directors that involve their main vendors, that involve their banks, their bankers, and their key business contacts. And they may meet once a quarter or once a year or whatever they think is appropriate, but it gives them an opportunity to sit and talk with people who care about their business, care about their success, but also are objective, who are not in it every day, and can give them good advice and give them objective advice, and perhaps tell them it's not quite as bad as they think. And those people are a tremendous source of information. Another is a senior industry figure in your industry. I've always been lucky for most of my career to have adult supervision. When I started out, I was in a big firm, and it was Armstrong Allen, which has undergone some changes, but a long-time great Memphis firm. And those older lawyers in that firm would tell you, how to do things and so forth. And so when I went out on my own, I still kept contact with them. I was partners for a long time with another great lawyer, John Wilder, who was practiced out in Somerville and was involved in politics for years. And even after we were no longer partners, I could call John up and explain to him what was going on, and he would give me some advice. And other lawyers to this day, that my new law partner, Bruce Kramer, who's been practicing a number of years. I've always tried to surround myself with people that were smarter than me, that were older than me, and who I could get advice from. And again, it seems to me to be an obvious thing, but I see so many of my clients don't really have that. So cultivate key industry figures that will be glad to, most people are glad to help out. Business coaches. There are a lot of, that's an up and coming industry. I think you're going to see that more and more people practicing as business coaches. And right now, I think, you got to have a little bit of caveat emptor there, because there are a lot of people out there doing it who may or may not know what they're doing. But again, it's about accountability. And when you're an entrepreneur and the buck stops with you, and there's nobody really to hold you accountable, it's good to be able to know, well, in a week, I'm going to meet with my business coach, and he or she is going to ask me, did I live up to the commitments I made the last time we talked? They're going to ask me, did I do X, Y, and Z? And knowing that, for some people, knowing that you're going to have that accountability will help you to stay on track and meet your goals. I'm just a big believer, and this is more of a philosophical commercial than a legal one, but I'm just a big believer that if you think I got to do it by myself, and if I ask for help I'm cheating, I think you really are missing the boat. Because I don't believe that there's anybody. You listen to all of the memorials and testimony people are giving about George Steinbrenner. One of the things you hear about is what a people person he was. He wrote notes to people. He talked to people. He didn't compromise his standards. They all say, well, he was a perfectionist. Derek Jeter, they're talking about they lost in Game 7 of the World Series, and he's already talking about there's going to be changes next year. You won the pennant. You came within 2 outs of being a world champion. You're going to make all kinds of changes. He demanded perfection, but he relied on the people around him, and especially in the latter part of his career with the Yankees, people said, he didn't try to do it all himself. He tried to build good teams. And so building good teams of advisors, building good teams of employees is one of the best ways to build a good business. And if you think you got to do it all yourself, you're wrong, because you can't. You got to have customers, you got to have employees, you got to have suppliers and vendors, and all of those, behind all of those logos, behind all of those emails and fax numbers are people. And if you're a people person and you listen to people and seek people out, I think that you'll be successful. Which is a great segue into doubling back to employment law compliance. I recommend to every audience I speak to the book, The E-Myth Revisited. And if you haven't read it and you'd like a copy, give me your business card. I'll be glad to send you a complimentary copy of it. I don't get any royalty. I just think it's a great thing for people to read. And one of the concepts in that goes along with what I've just said, which is you've got to get the right people on your bus. You've got to have a good team, and you've got to have them performing their duties well, and you have to know whether or not they're performing their duties well. You say, what does that have to do with employment law compliance? I always say that businesses need to look at the employment laws as an opportunity to improve their business, because compliance with the employment laws is good business. And at the bedrock of it all is you have to know what your business is about, and you have to know what each individual position in your business is about, and what it does, and what it takes to be successful in those positions. Now, having said that, can anybody tell me what one thing you can do that will have a direct one-to-one correlation, that if you do this thing, you will never get sued for employment discrimination through termination? Anybody want to give? Yes, sir.
Contract agreement, employment agreement.
No. Good idea. I like contracts. Yes, sir.
Never hire anyone.
All right, you're very, very close. Very, very close. Never fire anyone. All right. If you never fire anyone, you're never going to get sued for wrongful termination, right? Well, all right. So the goal is, how do I get to a point where I don't have to fire anybody? And you say, well, Crone, that's stupid. Well, it's not if you really think about it. Everybody that I have ever talked to, whether I'm representing an employer or an employee who's been fired or who's had to fire someone, they all started out, that relationship all started out very optimistically, right? I mean, very, very seldom, although I realize in some industries and some circumstances you have to hire some folks that maybe you don't want to hire. But basically you say, this is the best person I can find to do this job, or I wouldn't have hired him. And generally speaking, most of the time, taking everything else out of the equation, all the allegations of discrimination, it comes down to communication, or a lack thereof, and a lack of confrontation, positive confrontation between whoever's managing that person and whoever is performing the work. And so the first thing you have to do to be in compliance with employment laws, ultimately, although there's no requirement legally that you do this, is you've got to have a good job description. And by good job description, I mean it has to actually reflect what the person is doing and how they're contributing to your company. And so often I see human resource professionals or business owners take that job description as, well, I gotta throw a job description together and I gotta check that off my list. And so they come up with a job description that over time, and once they create it, they forget about it. And over time, it doesn't reflect what's going on in reality. What that means is, it affects everything from Fair Labor Standards Act compliance. That's a big hot topic right now. Wage and hour issues, overtime, minimum wage. If you don't actually know what the people are doing in those positions, you cannot adequately determine whether or not you're in compliance with the wage and hour laws, and that can be a huge hit. If your company grosses not nets, but grosses $500,000 in revenue, you're subject to the Fair Labor Standards Act, which means that if the employees working for you are exempt or not exempt from that act, then you have to pay them time and a half overtime. And if you guess wrong, and the Department of Labor comes knocking, all right, then you're going to pay big time. And not only going to pay big time, but the Department of Labor is going to force people to take that check. You hear that? The Department of Labor will force people to take that check. And this particular Department of Labor that we're dealing with now, let's just say they're a little more aggressive with that than they were under the previous administration. So that's out there. And then there are private attorneys like me who take those cases, and you know that is a growing area within the plaintiffs' bar of going after the Fair Labor Standards Act, because it doesn't matter what your job description says. It doesn't matter that you pay them a salary. Okay? What matters are the duties that those people are actually performing in each work week, exempt or non-exempt. And I don't care if it's Saddam Hussein, your employee, they're the worst employee you ever had. The question is, did they do the work? Was the work non-exempt? And if you don't understand, or your company doesn't understand what that employee is actually doing on a day-to-day basis, if you're just relying on an outdated or irrelevant job description, then you're opening yourself up for a liability. Same thing with Denise Higdon and her company, Worksite Consultants, who do employee testing. All right? If she's testing for physical limitations that you really don't require your employees to do, you may be testing for some physical limitations that they don't necessarily need, not testing for others. In any event, she's wasting her time and your money if you don't adequately understand that. Going back to my original idea of not firing anybody, if the person, one thing that I always tell interviewees, someone looking for a job, and they may come to me and say, what advice do you have? I always say, ask this question: what does it take to be successful here? And you would be surprised the number of interviewers who cannot answer that question. And you would be surprised the number of supervisors who cannot answer that question. So if you don't understand what the person's supposed to be doing, if you don't understand how that particular position adds value to your business, then how can you articulate what the essential functions of that job are? And how can you really articulate to the person that you're supervising what they should or should not be doing? And I'm just here to tell you, I've seen it from both sides, and time again, that's what those lawsuits come down to, really, when you strip it all away, is most people don't seek out to sue their employer if they really feel like they did a bad job. But oftentimes people come to me and they say, I don't have any idea why I got fired. And so it must be some sort of discrimination. They happen to fall into a protected category. All right? And so that's where those lawsuits come from. And conversely, when I'm talking with management, when I'm advising management, and I say, well, why did you fire them? Well, they were just terrible. All right, well, that's a conclusion. All right? You've drawn that conclusion. All right? And that's your perception, that's reality. Tell me the facts upon which you base that conclusion. I don't know. You've got to understand. And so that goes back to everything you've ever heard about progressive discipline and documentation and all of that. You can document things to the ends of the world, but if it is all subjective, pie in the sky, conclusory stuff, it's not going to hold up. And that generally comes from going back to this idea of not having an idea of what the job is, not understanding what it takes to be successful, and not having the adequate training of that person to do the deal. And you have to train, you have to communicate expectations, let the person know, look, you have got to be here by 8 o'clock. Period, paragraph. Not 8:01, not 8:05. You need to be here at your desk at 8 o'clock. And if you hold people to that standard and clearly articulate it, you're probably not going to have a problem. But if that particular injunction hasn't been firmly communicated, or it's not clear why that's a legitimate expectation, then you're going to have that interpersonal conflict that will result in having to terminate that person down the road. And then the last thing I'll say on this is confrontation. I have become over the years a big believer in what I call positive confrontation. And that is confronting someone and saying, hey, Blake, 8:05, you know you're supposed to be here at 8 o'clock. I need you here at 8 o'clock. Can you do that for me? Sure, great. That's a confrontation. That's a positive confrontation. All right? Hey, the example I always use is my former law partner, who many of y'all know, Miles Mason, who is, I hope none of you need him, but he's one of the better family law practitioners in town. When we first got together, he had a specific way that he liked to have documents stapled. He's also a CPA and a type A personality. He had specific, the specific angle, specific way, specific place. And finally one day he was going on about some secretary that he had, and she's just terrible. I said, tell me what it is, Miles. Well, she doesn't staple correctly. I said, well, have you ever told her about it? He said, well, I told her it's not right. I said, Miles, you got to go in there, and you got to tell her, if it's that important, and tell her why it's important. Now, there was a reason why it was important. It was the way that when he was in court, it was the way that he wanted the papers to fold over the thing. All right? He's a business owner. If he wants things stapled a certain way, it's his right to have that, to expect it. But he needs to communicate that to people, right? And he needs to tell them why. There are a lot of people that they'll do it as long as they know why. But if they think you're just being arbitrary, not going to understand it. But you got to get self-aware. You got to understand why you want it that way. How does it add value? And communicate that to the employees. And most people, if they're worth a damn, they're going to want to comply with it. They're going to want to do a good job. But if they don't really know, they don't really understand, then you're barking up the wrong tree. Next topic is intellectual property. And this is also very, very similar to what we're talking about here. You have to understand how your intellectual property adds value to your business. And I would posit that today, in today's economy, it's not about where your office is located. It's not about what kind of smile you have or anything like that. It's about the competitive advantage that your business has that does whatever it does better than the competition, right? That's intellectual property. And I have and can do a 2-hour deal on intellectual property, but the bottom line there is you got to know your business. You got to understand what it is about your business that gives it a competitive advantage, and you have to have a plan for that. And you can't just say, well, I'm too small now. Just like in employment law. I've only got 3 employees. I don't have to worry about all those employment laws. They don't cover me. Well, someday you hope to have 20 employees, and then everything will cover you. And if you wait until you have 20 or 30 employees to start thinking about compliance, then A, the cost of compliance is going to go up, and B, your chances of actually being on top of it and getting ahead of it before you get a claim is greatly reduced. So when you got 5 employees, 3 employees, act like you got 30 employees. Same thing here. Act like you've got some intellectual property to protect, even though you're trying to build it up. You know, if somebody gave you a gold dollar, you put it in a safe place, even though the safe is built for 5,000 gold dollars. You're still going to put that one gold dollar in there, hoping it's going to have some buddies soon. So it's the same thing here. If you're trying to build intellectual property, then go ahead and begin to protect it through copyrights and trademarks and patents and all those wonderful things. And then again, use those tools properly. And again, don't let someone say, well, the standard thing to do is you do this, that, and the other. Well, whoever tells you that is just trying to sell this, that, or the other. What you want to do with intellectual property protection, like anything else, is it's got to be handcrafted to your particular situation and protect your intellectual property in a way that not only is going to keep your competitors from stealing your ideas, but is saleable. Right, we're entrepreneurs. We want to sell our business, theoretically, at least at some point, or have our heirs sell it at some point. And one of the ways to build up that value is through the protection of intellectual property. And you have to have written policies to protect it. Again, you have to have training and communication with your people so that they understand the value of that intellectual property. There are all kinds of agreements and branding elements for trademarks and copyrights and patents. And so the idea is that as you build that box, you are filling it with value, and it's not going to go anywhere. Quick war story that I hope illustrates this point, a lot of these points. I did a lot of non-compete enforcement work, and that's really how I got into intellectual property, was through employment law. I would either defend or prosecute non-compete cases. And usually, although not always, non-compete enforcement comes down to protection of intellectual property. And I was in Utah for a month one weekend, and I had was doing deposition prep for the regional manager of my client, and we talked the whole time about their protection of intellectual property. And what they were doing is they had bought this huge empire. People were starting to leave, and so they were going to protect the fringes of the empire by going after the salespeople that were taking their customers and leaving. Okay, that's the context. And we spent the whole weekend literally talking about all the ways they protected their intellectual property, the crown jewel of which was their customer list. And it was a great customer list, and I won't bore you with all the bells and whistles, but it was more than just name, address, and phone number, as you can imagine. Well, they had it password protected. They, this, that, and the other. All looks great. At the end of the day, Friday afternoon, calling my office, and I'm standing at the reception desk to call, and it's one of those reception desks we've all seen. They have the counter about this high, and the receptionist sits back here, and I'm standing at her desk, and I'm on the phone, and I'm on hold, and I'm kind of looking down this thing, and at the end, right here, was a computer printout. It's back in the old days when it was in those long deals, the green and white stripes. And written across the top of this in black Sharpie was customer list. So Debbie, the receptionist, comes back, and I said, "Debbie, what's that?" And she says, "Oh, I'm not supposed to have that. Don't tell anybody. I'm not supposed to have that." I said, "Well, Debbie, why do you have it?" She says, "Well, the salesmen come in, call in from time to time, and they need information off the customer list, and the only person who has access to it is the sales manager. And he got tired of having to stop everything he was doing and looking up their information, so he just printed it all out for me, and I have it. When they call in, I can just read it to them." All right, well, there are about 500 things wrong with that, but the lesson is, no one had really ever communicated to Debbie the importance of that customer list and the fact that it was a trade secret, and the fact that, if she's going to do that, at least put it in a drawer. Again, like I said, there are all kinds of problems with it, but, just the fact that she had absolutely no idea why she shouldn't have it or whatever, that just shows the importance of training, and training all the way down to the last elements of the line elements of your company. And if those people, if you do it if it's something that you really do on a day-to-day basis and is inculcated into them, then I don't have to prep them for a deposition. They're going to answer the questions the way you want them to answer it, because it's second nature to them. But if I have to prep them and get these people to say, "Oh, well, it's an important," it's not second nature to them, and it's not as credible. It's the same thing with employment. If your progressive disciplinary policy is aimed at discipline, that's going to come through. If it's aimed at creating better employees and giving everybody the opportunity to succeed, that's going to come through. Last thing I'll talk about is customized agreements. Again, if you sign something, you bought it, and you bought all the language in it. And I'm not saying that you need to take it to a lawyer every time you sign a sales agreement or something like that, but an ounce of prevention is worth a pound of cure. And having someone, if nothing else, explain to you the risks you have just allocated and the obligations you have just taken on in signing that agreement. Even if a lot of people say, "Well, it's not negotiable, they're not going to negotiate." Okay, but at least understand what it is you sign and understand what it means from a legal standpoint. And please, please, please don't use common sense, because common sense left the courthouse a long time ago. But again, and make sure that whatever agreements that you draft and you craft are drafted and crafted with your business in mind and the specific risks and obligations that you want to allocate, because that's what a contract is. Contract fixes and eliminates variables of risk and sets obligations. Think about every contract you've ever signed. That's what it's designed to do. And if you just take something off the shelf and use it without customizing it to your situation, whether you do it or you have a lawyer do it or you have your cousin Bonnie do it, then you really have no idea what it is you've just done. And so understand those things, because again, some of those risks may be risks that you're willing to take, but some of them may not be, and they may be deal stoppers. And so you just need to know. The last thing I'll talk about is risk management. And again, I think this is one of those things that people just overlook because they feel like they don't have the time to deal with it. With the tip of my hat to the insurance industry, I will say probably the best risk management plan is just having lots and lots of good insurance. You know, that covers a lot of ills, at least for the first time that you run into a problem. But beyond that, you have financial risk. Make sure that your business organization that you're using, whether it's an LLC or a corporation or a sole proprietorship or a partnership, again, make sure that that's what you need. You know, a lot of times if you go into a lawyer and say, I want to incorporate my business, lawyer will take out their corporation form, they're going to do it because that's what you've asked them to do. But probably what you want to do is say, hey, I'd like to talk to you about what the best business organization is for my company, because then you're going to get a better result that way. And again, as they're using standard agreements, read them and customize them. It may cost you a little bit more to do it that way, but again, you're going to come out with a better situation. Have a collection strategy in place in terms of AR and AP. Know how you're going to collect your money. Get good relationships with factors and or collection agencies and collection attorneys, and make sure that you've got good language in your sales agreements. Make sure there's an attorney's fees clause in your sales agreements. I can't tell you how many people come to me to collect money and they don't have an attorney's fees clause in their agreement. I say, well, I can get you a judgment, but I can't increase it I can't increase it because of my fee because it's not in your agreement. In Tennessee, it has to be written in the agreement. Have a specific schedule and form on how somebody is responsible in your organization for collections. Have an exit strategy. You know, be thinking about what happens when I sell this business. What happens when my kid's going to take over this business. That's what we're all in this for, to a certain extent, is to be able to build up a good business and sell it. Casualty, again, business organizations come into play there. You may not need an LLC or a corporation if you're not in a high-risk casualty business. You know, but if you've got people running around town in cars with your name stamped on them, then you need to be a corporation or an LLC, and you need to have lots of insurance. There is employment law insurance out there. That's a situation where you've got to be, I think, a lot of caveat emptor. They have high deductibles and everything else, but make sure that it goes with you. And safety and OSHA compliance, again, I think is an area where businesses look at that and say, oh, that OSHA is just another bunch of regulations that I got to deal with. Well, you know, if you're in OSHA compliance, we were talking about this at lunch, if you're in OSHA compliance, maybe you're going to have less accidents, and so that's going to decrease the amount of workers' comp that you have. But have a plan and have somebody responsible for it and review it. In closing, I'll just say that you know, everything I really am saying is that there are very few things, I think, from a legal standpoint that you can just establish and not cultivate, not maintain. And your legal situation, your risk management situation, all of these situations have to be maintained just like you have to maintain your physical plan. because everything, your operation is going to change over time, and if you're not looking at it, it's not going to be performing the way you want it to perform. Any questions? Yes, sir.
The increment in your collections for attorney's fees, they have to be reasonable, correct?
Right.
And that has the verbiage. You need to be very careful about putting that in there. In English law, is that still pretty good use? English law, losers pay?
Well,
do the courts here recognize?
oh yeah, if you have an attorney's fees clause in an agreement, then they're going to honor that. And depending upon the type of case, the courts here are in most collection cases are not going to reimburse you more than a third of whatever the amount in controversy is, even though you may be on an hourly rate basis with your lawyer. But that's something, again, you need to make sure you talk about with your lawyer about. Yes, sir.
On the advisor thing, I really believe in peer groups. I'm in a fantastic peer group of the societies led by Pearson here. On the advisors, the BOA type of thing, do you recommend that these folks are compensated, or they're just doing it because they care about your business, or how would you recommend kind of putting that together?
I think it depends on who the folks are and how loyal they are to you, and how much your success benefits them, whether or not they're going to do it. I'm a big believer that you ought to give them something, whether it's a really nice dinner. I know one of my clients takes everybody on a trip, to something like maybe Dancing Rabbit or someplace like that, for an overnight, and then a retreat on Saturday and a meal or whatever. And I know some people compensate them for it, and I think it's whatever you think are going to be the most to motivate those people to show up and give you good advice. I don't think there's a right or wrong answer there. Just whatever it takes to get them motivated. And cash is pretty good motivator. I have found. I hear good things about cash.
We were talking about job descriptions, and I have two questions about that. Number one, should job descriptions sunset after a certain period of time? And you didn't mention anything about reviewing performance reviews.
I think a sunset of job descriptions is a great idea, and you can rotate them so you're not doing the whole deal at one time. And then you're right. Evaluations are a very, very important part, and I encourage people to have one evaluation that's kind of the formal evaluation, but to have periodic inventories as you go along. And my one advice on evaluations is, if you're writing them, is again, they need to be objective and they need to be specific, fact specific. And saying, well, you've got a bad attitude. I can't tell. I wish I had a nickel. Every time I've seen, Susie has a bad attitude on a performance evaluation. Very well may be true, but what is it that she has done that leads you to believe she has a bad attitude? And what can she do to be successful? Because again, if Susie ends up suing you for gender discrimination and you really can't articulate to the jury what it is she did wrong and how you empowered her to do better, then I say, my theory is that schoolyard justice comes into play there, and the jury goes back and they say, they did this woman wrong. The reason they gave for firing her, they can't support, so it must be gender discrimination. Judge says it has to be gender discrimination. We find gender discrimination, give her a whole bunch. But if they look at it and they say, look, these people bent over backwards for her, and told her exactly what to do, told her not to argue with customers on the phone in a loud voice, and she continued to do it, she needed to move on. So those are the kinds of differences that, and again, I always tell people, I don't care what kind of case you have, imagine yourself in a jury box listening to you tell the story, and you don't know you. You've never seen you before in your life. How persuaded would you be hearing somebody say those things? And if you're honest with yourself, you're going to get a good answer from that. Performance evaluation and documentation, just for documentation's sake, is just as bad as no documentation. If the documentation shows that your goal is to make this person a good employee and they just would not comply, I think 9 times out of 10 you're going to be fine. But if it shows that the only reason you're documenting is because you know you're going to fire this person, then all of a sudden people got all kinds of questions. And that's generally how most documentation of this one comes across in the cold, calculated environment of a courtroom. It comes across as punitive. It comes across as the result has already been decided. And normatively, people don't like that. You wouldn't like that. You know, if somebody, they've already decided I'm going to get fired, and they're just, now you're having, from an employer's standpoint, you're having to overcome that. Is there a legal requirement that you have to overcome it? No. But there sure is in that jury room.
Speaking back on everything that you're saying prior to me being in the Brazilian barbecue business, I specialize in workers' compensation. Everything he's saying is dead on. And there's also an objective way to gauge it in the insurance industry as far as, it's not good insurance, but there's something, if you are familiar with an experience modifier. That's an excellent way to gauge, and it's an algebraic equation, how well your business is doing. And the funny part about mods is that the majority of the time they're wrong. We'd go around and we'd audit people's experience modifiers, and we would, on the bat, get them insurance checks back from the insurance carrier just to correct that. Everything that he's telling you right now is how to manage that modifier, which in turn will save you ample amounts of money down the road, just for not paying too much for workers' compensation because of the OSHA compliance, because all that stuff all plays into how much you pay. There's a difference between paying 1.2 times $1 billion in insurance premium as a 0.8. You're saving 40% right off the bat, knowing this by doing what he's saying. So there's a tangible money, monetary purpose to do this. On top of it, it's just the right thing to do. That makes sense.
Well, that's a pretty good note, 10.
Are we done? We're done. Thank you very much.
Blake, I think